Amend the bill to the House.
Very good, very good.
Mr Chairman.
Oh, the Honourable Leanne Dalziel.
Mr Chairman, thank you for the opportunity to speak on clauses 1 and 2 of this very important bill. I want to begin by just traversing the policy that lies behind the legislation that we have in front of us tonight. And the first thing that I really want to do is to remind the House why the Reserve Bank came to the view that it was important to have local incorporation. And I think the reason for that can be brought back to the provisions of the Reserve Bank Act itself. In Part 5, the Reserve Bank is given powers to register banks and perform prudential supervision. Section 68 of the Act states that those powers must be used for the purposes of promoting the maintenance of a sound and efficient financial system, or avoiding significant damage to the financial system that could result from the failure of a registered bank. And we have been very lucky in this country, to be honest, by the system that we have in place, because we haven't had the failure of a registered bank the way that has occurred in other jurisdictions. And of course the behaviour that was identified in the global financial crisis as undermining the integrity of our global financial system stemmed from those that didn't appreciate the sense of confidence that people had in banks in general, and they were really let down by the behaviour of individuals who were running those banks and coming up with these amazing sort of derivatives and collateralised financial obligations, debt obligations rather, and various other ways of chopping and dicing and slicing the different levels of risk within products that then didn't make much sense really to anyone who knew anything about what they were supposedly able to advise people on. The Reserve Bank's supervisory regime, though, comprises three important pillars. One's the market discipline, which involves creditors and financial markets monitoring banks. Then you've got the self-discipline, which involves banks and their decision-makers responding to incentives to operate prudently and efficiently. And then thirdly, you've got the regulatory discipline, which is really where the Reserve Bank sets the prudential rules by which banks are required to operate. Now, when the local incorporation policy was brought into being, the Reserve Bank was only responsible for the prudential supervision of banks. It was subsequent to that, with the review of financial products and providers, which I was the lead minister on at the time, that a decision was made to actually extend the jurisdiction of the Reserve Bank to cover the non-bank deposit-taking sector. And in a way, if you could carve out the non-bank deposit-taking sector and their behaviours within New Zealand from what happened with the banking industry within New Zealand and Australia, and in that respect we were fortunate to be tied to Australia, then we could identify that in fact we suffered our own mini version of the global financial crisis, but located in the non-bank deposit-taking sector. So our decision to regulate in that area was, of course, entirely appropriate, and everyone says that maybe it should have been done sooner, but how much sooner than doing it as soon as the return on the discussion documents had been made available? I don't know whether that could have been done any sooner than it was. But leaving that aside, I think the point that is often overlooked is what happens when you've got such a large exposure to foreign-owned banks. And Australian-owned banks in New Zealand still account for, and did at the time, around 90% of assets held in our banking system. So that's an enormous benefit, but it's enormous exposure as well. And I think that was what drove the Reserve Bank to consider the whole issue of local incorporation. So their view at the time was that foreign ownership acted as a channel through which distress from abroad could spread to New Zealand, and that was the risk that was really the risk that they were trying to address. And what that meant was that although they looked like New Zealand banks in name, Australia, New Zealand Bank, Westpac, Banking Corporation, New Zealand, what would happen is that they had the ability and indeed the incentive to act in ways inconsistent, Mr. Chairman, with promoting a robust and efficient New Zealand financial system. And that was the problem, was that potentially you could have the Australian bank behaving in the interests of the Australian bank and not actually acting through its New Zealand branch in the best interests of the New Zealand banking system. And that's why the Reserve Bank felt that it was really important to undertake the review of its policy in the early 2000s. And I think my colleague does make the point that Westpac did try to find alternative ways of addressing the policy intent without meeting the regulatory obligations that were being worked through by the Reserve Bank. And to be fair, they did put up a proposition which the Reserve Bank of the day did consider, and they declined to accept that at the end of 2004, and as a result we dealt with legislation in 2006 which brought the Westpac New Zealand Act of 2006 into play. But I guess the one question that I still haven't quite had answered is this, and that is that the Westpac New Zealand Bill 2006, or the Act 2006, was obviously designed with a view that the transfer that occurred at that time would be the one and only transfer that would be required. And I'm not sure whether that it was deliberate that that would be the case, or whether it was just an assumption that that would be the case. And I guess I'm wondering whether we're having this debate on this piece of legislation tonight because we didn't have sufficient foresight to understand that the rules would again come into play. And I think I should put that on the record, that the reason why we're having this debate tonight is that the condition that was reached with the Reserve Bank of New Zealand in terms of its local incorporation policy requiring that systemically important banks be incorporated locally in order to provide a degree of assurance that the Reserve Bank would have the ability to manage a failure affecting the bank. One of the conditions is that branches do not have New Zealand liabilities, excluding those to related parties, in excess of $15 billion. So the question was that, because that's the cut-off point where they suddenly become systemically important. So that means that the Westpac branch that remained at the time in 2006 did not reach that threshold of systemically important, but now it does, which actually says something pretty amazing about the extent of business that Westpac has managed to generate in the institutional banking sector over that period of time. And I've already confessed my conflict of interest because I, of course, bank with Westpac, so I'm saying positive things about them, but not for that reason. But it does appear that they've reached that threshold in that period of time. But the question is that does that mean that if that happens again with what remains in the branch of Westpac Banking Corporation, does that mean that we could be having another piece of legislation in order to address this, or will this piece of legislation be sufficient to enable a further order in council to be made in terms of transferring assets and liabilities in order to keep that liabilities cap in future below that level where indeed the Reserve Bank would require this process to be undertaken. So, I mean, that's really probably the only sort of outstanding question that I have in that regard. I take it that the member's not going to stand and advise the House whether they're in the qualifying financial entity area, and maybe that means that it's not as relevant as it would otherwise be. But I guess I want to know whether this piece of legislation has life beyond 2011 or whether it has a limited life, as did the 2006 Act, and whether other banking institutions that may have the dual registration, I think there are others, I think Rabobank's one of them, I think there are others that have that dual registration. Are we going to end up having a multiplicity of legislative interventions as opposed to regulatory interventions by way of order in council, because that would make a lot more sense to me.
Stuart Nash.